Good morning, one and all present here. I, Ms. Samruddhi Milind Tiwatne, student of 5th year BLS LLB of Janardhan Bhagat Shikshan Prasalak Sanstha's Bhagubai Changu Thakur College of Law, New Panvel. I welcome our chief guest, Principal Ma'am, all the professors, and everyone present here for this wonderful 5th day of late Sri Janardhan Bhagat Memorial Lecture Series. As we have inaugurated the late Sri Janardhan Bhagat Memorial Lecture Series on 27 January 2024 with the great presence of Advocate Dilip Shinde Sir, Senior Advocate of Bombay High Court, on the topic of criminal justice system in India. The second lecture was headed by Advocate Gajanan Chavan Sir on the topic Bail Application on 29th Jan 2024. Third lecture was headed on 30th January 2024 that was delivered by Honorable Justice Pradeep Deshmukh Sir, former judge of Bombay High Court on topic Evaluation of Evidence in Criminal Trial. On 31st January 2024, we heard Dr. Karuna Malviya ma'am on lecture on the topic of victimology. And today we are pleased to hear Dr. Anil Variath Sir, Registrar of Maharashtra National Law University. Before we proceed with our program, with due respect, I would request you all to please raise for the national anthem. पंजाब सिंध गुजरात मराठा द्राविड उत्कल बंगा विंध्य हिमाचल यमुना गंगा उज्जल जगति तरंगा तव शुभ नामे जागे तव शुभ आशीष भावे गाये तव जय गाथा जनगण मंगलदायक जय हे भारत भाग्य विधाता जय हे जय हे जय हे जय 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 हे भारत माता की जय. Please be steady for the Maharashtra Geet. Thank you, everyone. As a mark of respect to our esteemed founders, with guiding lights, Shri Janardhan Bhagat Sahib, late Shri Changu Kana Thakur Sahib, and late Shri Mata Shri Bhagubai Changu Thakur, we are absolutely honored to invite Dr. Anil Sir and our principal ma'am to light the lamp of enlightenment of knowledge and understanding of today's lecture. Thank you, sir. Thank you, ma'am. Students, please join us to welcome our today's guest. I request Ms. Sanvi Deshmukh, ma'am, to welcome today's guest of honor, Dr. Anil Variath, sir, with a memento, shawl, and sapling as token of collective endurance. Thank you, sir. Thank you, ma'am. Now, to embark the Janardhan Bhagat Memorial Lecture Series, let's bring the audience another piece of verse that reflects the contribution of late Shri Janardhan Bhagat Sahib in the field of education. For this, I would like to call upon stage Ms. Anamika Joshi, student of BLS second year.
नमस्कार, शुभ प्रभात. मी अनामिका बळीराम जोशी, BLS द्वितीय वर्षाची विद्यार्थिनी. आज मंचावर उपस्थित असलेले आपले प्रमुख वक्ते डॉक्टर अनिल वरियत सर, प्राध्यापक मिसेस सान्वी देशमुख मॅम आणि माझे प्रिय विद्यार्थी मित्र मैत्रिणी. आज आपण आपल्या कॉलेजने आयोजित केलेल्या द लेट श्री जनार्दन भगत मेमोरियल लेक्चर सिरीज या कार्यक्रमाच्या निमित्ताने मी आज तुम्हा सर्वांसमोर भगत साहेबांच्या जीवनातील प्रवासासंदर्भातील एक किस्सा तुमच्या समोर सादर करीत आहे. प्रवास. सामाजिक कार्यात खऱ्या अर्थाने पडलेल्या भगत साहेबांच्या जीवनाला वेळापत्रक नव्हतंच. कोणीतरी पहाटे 4 वाजता येऊन दार ठोठवायचं आणि भगत साहेबांना पहिल्या 6च्या गाडीने अलिबागला घेऊन जायचे. जाताना पनवेलवरून तर येताना रेवसकरंजा या मार्गाने यायचे. एका फेरीत जास्तीत जास्त कामं पूर्ण करण्यासाठी केलेली ही धडपड असायची. दिवसातील जास्तीत जास्त वेळ एसटीच्या प्रवासात घालवणारी जी काही मोजकी माणसं आहेत त्यात भगत साहेबांचा फार वरचा नंबर असायचा. भगत साहेबांना प्रवासाची आवड निर्माण होण्याचं दुसरं कारण म्हणजे शेका पक्षाचे ज्येष्ठ नेते व सरचिटणीस श्री ND पाटील साहेबांनी पुरोगामी लोकशाही दल या मंत्रिमंडळात असताना गाडी वापरली तेवढीच, पण त्या आधीचं व नंतरचं आयुष्य हे त्यांनी ST प्रवास करण्यातच घालवलं. त्यांच्याकडूनच भगत साहेबांनाही हा STने प्रवास करण्याचा धडा घेतला असावा. भगत साहेब सांगायचे, प्राध्यापक ND पाटील पुरोगामी लोकशाही दल या सरकारमध्ये असताना मंत्रिमंडळाचा कालखंड सोडता कुठल्याही गावच्या गोरगरिबांचा लढा असो, पाटील साहेब सर्वांच्या आधी आंदोलक म्हणून हजर असायचे. 1962 पासून 1984 सालापर्यंत शेका पक्षाचं ऑफिस पनवेलच्या जय भवानी नाक्यावर होतं. त्या काळात रेशनिंगच्या विरुद्धचा लढा, दुष्काळी कामाचे आंदोलन किंवा अन्याय अत्याचार विरोधाचा लढा असो, ND पाटील शेका पक्षाच्या मोर्चात सर्वांच्या समोर उभे असायचे. असा हा परिस्थितीने जोडावयास लावलेला प्रवासाचा संघ हळूहळू भगत साहेबांना जडून गेला. भगत साहेब स्वतः पंचायत समितीचे सभापती, उपसभापती होते. स्वतःची गाडी असणं त्यांच्या पदाच्या दृष्टीने आवश्यक होतं, परंतु त्या बाबतीत त्यांनी कधीही विचार केला नाही. त्यांचे जावई श्री रामशेठ ठाकूर साहेब यांना भगत साहेबांचे होणारे हाल बघवले नाही. आपण एक जीप घ्या, त्याकरता मी सहकार्य करीन असं रामशेठ साहेबांनी सुचवलं आणि त्यांनी जीप घेऊन दिली. पण भगत साहेब कर्णाचा अवतार रोज जीपमध्ये 10-15 कार्यकर्ते घेऊन पनवेल, जासई, न्हावे, अलिबाग अशा चक्रा सुरू झाल्या. पण गाडी ठेवणं सोपं नाही हे भगत साहेबांच्या लक्षात आलं. जीपला डिझेल हवं, ड्रायव्हरला पगार द्यायला हवा, शिवाय मेंटेनन्सचा खर्च. दर महिन्याला हे 3-4 हजार रुपये आणायचे कुठून? जीप तशीच धूळ खात पडली. काही दिवसांनी विकून बँकेचे थोडेफार कर्ज घेतले होते ते द्यावे लागले. जीप गेली तरी सुद्धा भगत साहेबांनी अगदी मनाला समाधान मिळेल एवढं प्रवास एसटीने केला. महाराष्ट्र दर्शन त्यांनी केलं, तसेच सारा भारत दृष्टीपथाखाली घातला. त्यांनी एकट्यांनी असा हा प्रवास कधी केलाच नाही. लोकप्रतिनिधी मिळाले नाही तर मित्रमंडळीच घेऊन ते प्रवास करत असत. ज्येष्ठ नेत्यांसोबत त्यांनी जसा प्रवास केला तसाच शेतकऱ्यांसोबत, माळकरी व वारकरी यांच्यासोबतही केला. ते ज्या ज्या ठिकाणी गेले त्या त्या ठिकाणची प्रेक्षणीय स्थळं त्यांनी पाहिली, तशीच शेतीही पाहिली. लोकांचं राहणीमान व रीतिरिवाज डोळ्याखालून घातलं. प्रवास करून जे ज्ञान मिळालं ते त्यांनी आपल्या मित्रांना व शेतकऱ्यांना दिलं. ते म्हणायचे, तुम्हाला सुख हवं असेल तर एकतर भागीरथाची गंगा तुमच्या शेतात उभी करा, नाहीतर घरात ज्ञानगंगा निर्माण करा. याशिवाय उद्धाराचा दुसरा मार्ग नाही. खरोखरच अशा काही प्रसंगांमधून त्यांचे आचार विचार किती महान होते याची आपल्याला कल्पना येते. धन्यवाद.
Thank you, Anamika. I may request our college librarian, Ms. Janvi Boyer ma'am, to join us the stage for the welcome address.
Thank you, Samruddhi. A warm good morning to all. I, Ms. Janvi Boyer, librarian of Bhagubai Changu Thakur College of Law, welcome you all on the 5th day of late Shri Janardhan Bhagat Memorial Lecture Series organized by Janardhan Bhagat Shikshak Prasarak Sanstha, Bhagubai Changu Thakur College of Law, New Panvel. A special welcome to the guest for the day, Dr. Anil Variath sir, former Registrar of Maharashtra National Law University, Mumbai, and our principal, Mrs. Sanvi ma'am, for today. Before we dive into the heart of today's event, let me take a moment to reflect on the esteemed personality we are honoring through this lecture series. Late Shri Janardhan Bhagat Sahib, who was not just a legal expert but beacon of justice. His commitment to the principles of law continues to inspire generations. This lecture series stands as a tribute to his legacy, a legacy we aim to uphold and carry forward. We have gathered today with immense respect and a sense of purpose as we embark on this intellectual journey, focusing on the theme of criminal justice system in India. In the diverse and dynamic landscape of India, our criminal justice system faces multifaceted challenges, from ensuring access to justice for all, so safeguarding human rights, to addressing issues of efficiency and fairness. The complexities are many of types. As we embark on this intellectual journey, let us recognize the role each one of us plays in shaping the future of our legal framework. Once again, I welcome you all and appreciate your presence in today's session. I now request Samruddhi to take over the dais. Thank you.
Thank you, ma'am. As one of the philosophers says, success is not an overnight achievement, but the result of continuous dedication and hard work. Sir, we are luckiest to have you, and we are eager to listen your lecture about Indian Constitution and criminal jurisprudence. But to know more about this great personality, I would like to call upon stage Ms. Prerna Gaikwad, student of 4th year BLS LLB.
A very warm good morning to our esteemed guest, our principal, distinguished professors, and my dear friends. It is my honor and privilege to introduce to you Dr. Anil Variath sir, a luminary in the legal profession and academia. Sir is currently holding the prestigious position of Registrar in the Maharashtra National Law University, Mumbai. Dr. Variath is not only a beacon of knowledge but also a stalwart in academic administration. His commitment to excellence is exemplified by his concurrent role as director of the for Research in Criminal Justice and as a chair professor and director of the esteemed Justice M.L. Painse Chair in Environmental Laws. Prior to his tenure at Maharashtra National Law University, Mumbai, he has served as a distinguished faculty member at Amity University's Law School, Mumbai, where he held the positions of professor, head of the institution, and deputy director, further solidifying his reputation as a leader in legal education. With a career spanning over 2 decades, Sir's expertise encompasses a wide array of legal domains, including constitutional law, corporate governance, international humanitarian law, comparative public law, and environmental law. His scholarly contributions extend beyond the classroom with 4 authored books and over 30 published articles, illuminating crucial facets of the legal landscape. Professor Variath's dedication to academic mentorship is evident in the 3 PhD degrees awarded under his guidance, a testament to his commitment to nurturing the next generation of legal scholars. His profound insights and invaluable contributions have also been sought at the highest levels of legislative scrutiny, as evidenced by his appearance before the Parliamentary Standing Committee on the Clinical Establishment Registration and Regulation Bill 2007. Please join me in extending a warm welcome to Professor Dr. Anil G. Varath, whose presence enriches our gathering and whose wisdom inspires us all. Thank you.
Thank you, Prerna. Now, without wasting this valuable time, I may request our today's resource person, Dr. Anil Variath, sir, to take over the dais and deliver today's section.
Respected Principal, Sandy Madam, members of the faculty, and all the students who have assembled here, a warm good morning to you. I'm happy to be here with you and share a few of my views and ideas on the assigned topic. And also, I take this opportunity to congratulate the principal and the team for organizing such a lecture series in connection with the birth anniversary of the founder, late Sri Janardhan Bhagat ji. I understand that Janardhan Bhagat Sahab was a great social worker and he has contributed to the development of the society in this area. And I salute his wisdom in establishing educational institutions because it is through education where we can spread values in the society. A society without values is dead, intellectually dead. So his vision as early as in 90s to start institutions and to bring up these institutions to such a quality level by his successors also requires to be commended, and I think it is my privilege to be here. Coming back to the topic assigned to me, and again one more thing what I say, I understand that the entire lecture series is based on the criminal laws and criminal justice administration, especially in a time when the criminal justice administration is undergoing a vital change in India. So the timing is also very appropriate. See, actually, usually when we interact with the students, it should be something, some sort of interactive session. So I will convey some of my thoughts, and you can also contribute to that. You can ask questions, you can even confront that, because there must be multiple ideas and views in the system. Okay. So before venturing into my assignments, let me ask you one question. Some of you may give me an answer. Why there is criminal laws be in a system? What is the use of having criminal laws in a legal system? What's the purpose of criminal law? Anyone? Pardon? Someone told, what is that? खड़ा करके बोल yes
maintain the law and order, maintain the peaceful society,
yeah
maintain the dignity of the society while establishing the criminal law. It is the use to give the analysis of the criminal for the behavior.
okay nice maintaining law and order, peace in the society, and to transform the criminals for good behavior. Okay, any other use? Right. So right from the beginning of human civilization, we will see that criminal laws had occupied a distinct feature, distinct place in the system, every system, because of the potential consequence of failure. If you fail to obey the criminal laws, there will be potential consequences which we call it as punishment, isn't it? Because punishment means the person who is not obeying the law has to be put into certain difficult situation, certain position of disadvantage. We call it punishment. That is why Indian Penal Code, isn't it? So that is why we call generally the principal criminal law of every country will be known as a penal law, to punish the crime. That's why I asked you generally, why to punish? Because you have to maintain the law and order, peace in the society. If those who are breaking law is punished, others will not do the same crime in the society. Is it correct? If that was correct, there would have been only one murder in the society. It would have been in the Garden of Eden, when the children of one son of Adam killed his brother. God immediately punished. If punishment will deter others from committing crime, they would not have been further murder at all in the society. I will tell you one example. In England, in olden days, punishment was very, very, very severe. Even theft punishment of theft was awarded with the death penalty. In olden days, the death penalties were executed in public. Why? Because people should see that if you commit such a crime, you will be hanged in public, so that other people will not do the crime again. And you can imagine the climate of England. What's the climate? It's very hot there. Is it very hot? Then very cold. So they wear the woolen clothes and all, coat and big overcoats, long coats and all. And there will be 100 people, 200 people to witness the hanging. During this hanging is going on, there used to be a lot of pickpocketings. Right? You are watching what? You are watching the death sentence given to a person for theft. While watching that, the people will come to the thieves will come, they will pick the pocket from the long coats and all. So deterrent effect of punishment had always been in question. Even you see in India, Dandanidi says, Dina Danda Bhayat Sarvam Logam Shandaya Kalpade. Because of the fear of severe punishment, there is peace in the world. So even see, when you understand in a larger perspective, these theories are not only good, right? So what is the use of punishment? What is the use of criminal law? So criminal law basically provides certain rules to every society, which says that these things are legal and these things are not legal. So that will decide your actions and behavior. Then we can see there are three type of actions, human actions in the world. One is declared to be illegal, that is prohibited by law. Second is which is permitted by law, and third one is which is neither permitted nor prohibited. So these three things. So when you do an act which is specifically prohibited by law, it becomes what? It becomes a crime, isn't it? See, how many of you have done CPC, IPC? पढ़ लिया ना, हो गया ना आपका? Okay. So every crime is defined, well defined, and your act or omission, whatever it is, it has to make the ingredient of the offense. Then only punishment will be there. Beyond the definition, there is no crime, because crime should be very specific, isn't it? You cannot have random punishments, random crimes. Telling lies is a crime or what? Is it a crime? Yes or no? बोलो ना. Hey, how many of you say that telling lies is a crime? Yes or no? Yes. कौन बोले yes? Which section under IPC says crime telling lies is a crime? It is not a crime. It's not a crime. But if you file a false affidavit in the court, or you depose as a witness and tell a lie, it is a crime. So what is the difference? See, telling lies in your life, it is not a crime. If that was a crime, the entire hall would have been empty. But telling lies in the court of law or under a sworn affidavit becomes crime because it has been defined by law as crime. Law says it's crime, that's it's crime. Similarly, you might have studied the difference between culpable homicide and murder, isn't it? Is there a difference between the two? Yes or no? Whom? Is there any difference for the victim? See, the victim, suppose कोई मर गया, he's lost his life. Whether lost under culpable homicide or lost under murder, no difference for him. वो मर गया तो मर गया. Then difference is for whom? Is for the accused, because punishment differs. Why punishment differs? Because the definition says so. Definition says this act, if you commit, it is murder, culpable homicide amounting to murder. If these are the ingredients, it is not amounting to murder. So difference is by definition. Right. So this you keep in mind. Now, coming to the objectives of criminal law. First objective can be retribution. What is retribution? Taking revenge. अच्छा, eye for eye, teeth for teeth. उससे मेरे को मारा, मैं भी मारूंगा. Right. So that there's an urge for retaliation, revenge, settling the scores. Who has that urge? Every individual. If you give that freedom to individual, there will be in a chaotic situation. You might have also, even today also, you have instances of honor killing, family feuds, and all, isn't it? So the state has taken over the act of retribution. That is one purpose. It says that criminal law will put the criminal at some unpleasant disadvantage because to balance the scale of justice. Second objective is deterrent that we have seen, seeing that डर के कोई नहीं करेगा. But actually, fear is not the only factor which desists somebody from doing a crime, though it is one of the major factors, isn't it? Then another one is incapacitation, keeping a criminal, an offender, in the jail under imprisonment, so that he will not commit further crime. You know about preventive detention. If a person is apprehended or if there is a reasonable apprehension that he will involve in some crime, he may be taken into preventive custody. So that is one thing. And the more newer one, modern one that he has just told is rehabilitation, reformation. In reformation, you are see all these their retribution, deterrence, incapacitation, everything. You are addressing the criminal. You have done a crime, offense, offender is punished for the offenses done. But in reformation or rehabilitation, you are addressing not only the offender, you are actually addressing the offense, the crime. What is crime? Just now I told you, doing an act which is forbidden by the law is a crime. Why law has forbidden that? It has forbidden for the sake of the society. So crime is also a social institution. It is a social institution, just like our family, our marriage, our property. Crime is also a social institution because it has arisen from the society, it has grown with the society, it will grow, continue with the society, right? But there is a cause, there is a reason, there is a root cause for every crime that is in the society. So you address the situation, the crime as a social institutions, understand the underlying factors and try to mitigate that. Therefore, crime will not be there. I will tell you one very live case which you will understand easily. If you watch the movies of 60s and 70s, that will be Hindi, Tamil, Telugu, any language, one of the major theme in the films were smuggling of gold. And the hero will be fighting against the smuggler, sometimes as a police officer, sometimes as an individual, and the police most of the time comes the last. Nowadays, you don't have such movies. Why there is no such movies now? Now, gold smuggling movies are not there. Reason? After liberalization, smuggling has lost its relevance in the society. Now, what you have? You have drugs, drug addiction, right? Then mafias, all these things. In olden movies, you might have heard of dons, underground don. Now there is no don. Instead of don, you have mafias. So there is mafia. Political crimes, political criminals you have. That's why I told you every crime has a very close nexus with the society. So crime is to be addressed and understood as a social institution. That is the objective under the rehabilitation or reformative theory. And last objective is restoration, because certain amount of harm is caused by the offender to the victim, and that has to be made good, that has to be compensated by giving good value, good of the value. So a new jurisprudence called compensatory jurisprudence has developed in the criminal justice administration. So, in the olden time, if you say, the traditional concept of criminal justice administration, when you talk about criminal jurisprudence, it's a study of any legal system where the sovereignty and integrity of the country is state is likely to be affected by the direct or indirect act of an individual. Then criminal jurisprudence will emerge. And the fundamental principles of traditional criminal jurisprudence is that there must be proper investigation. And investigation must be unbiased, honest and just. Second, the entire emphasis of criminal justice is to bring out the truth behind the case. That is why through an inquiry by the competent court. What is the difference between inquiry and the investigation? Who conducts investigation? Inquiry? Court. Court conducts the inquiry and investigation conducted by the police or investigating agency. So the golden rule of criminal justice is accused is or shall be presumed innocent unless the guilt is proved. That is what we follow, adversarial system we follow. So criminal law basically connected with the two things. One is the area of crime and other is applying to the laws applying to the criminal. See, crime means defining the crimes. Theft, rape, murder, culpable homicide, attempt to murder, dacoity. See, what is the difference between dacoity and robbery? Okay, what is extortion? Taking money from you by putting you under fear is extortion. I did not even touch you. Need not even come to you. I can give you a telephone call and tell you, "Paisa मेरे पास आना है, नहीं तो उठा देना." You will get frightened and you will give you the money to extortion. Then one is theft. Theft without your knowledge, your valuables are taken away. डर किसका पास है? चोर के पास डर है, isn't it? मारा गया तो उसको मार खाएगा. Then what dacoity? There is also no application of force. Dacoity, what is under dacoity? Sorry, robbery. When force is applied, theft becomes robbery. If more than 5 people are there, 5 or more people are there, becomes dacoity. So only definition matters, isn't it? So that is first part, applies to definition of crime. Second part is applying to the criminal. What happens? Suppose you do theft, this is a punishment. If it is robbery, this is a punishment. Dacoity, this is a punishment. Punishment is also prescribed. Beyond that, there cannot be a punishment. Suppose the maximum punishment for an offence is 5 years. The judge feels, so 5 साल नहीं, so 10 साल देना चाहिए. Is it possible? No, because it's already defined. It's all defined. You cannot act beyond that. So, in the traditional US criminal law, there are been two classifications. One is called felonies and other is called misdemeanors. Smaller offences, major offences. In India also you will find cognizable and non-cognizable offences. This is there. Now, you tell me, you know about what is a national bird, national flower, everything you know. So, what is our national motto? Our national motto is Satyameva Jayate. What does it mean? Only truth will. See. So it's a verse from Manduka Upanishad, inscripted in Devanagari script, at the base of the national emblem. It was adopted on 26th January 1950 as our national emblem and national motto. You will find this in every court. If you go to any lower court up to high court, you will find just behind the judge, you will find Satyameva Jayate. I am telling this. Till now, what I told is applicable to all the legal systems in the world with a lighter difference, little difference. And when you speak about our Indian Penal Code, our principal uh, criminal law, who enacted that? Can anyone say who drafted the Indian Penal Code for us? Hmm? बोलो ना. But who? Who was the person? Who was head of? Lord Macaulay. It is the first law commission headed by Lord Macaulay, and with two other members, they present the draft to the Governor General. Okay, that I will come to that. So, understand, our criminal laws have been enacted by an imperialistic regime. For what? For controlling their subjects. Understand, the difference between the government and people was government and subject. The subjects who were slaves, who were not independent subjects, who were not independent citizens. So the controlling aspect was more, punishment aspect was more. Understand? So your rights was not recognized by the government. We were fighting for our rights. We were fighting for freedom. We were fighting for liberty. We were fighting for equality, freedom of speech, expression, movement, demonstration, everything. And see, every constitution, you understand, it is a product of some or other revolution. Maybe military revolution, maybe democratic revolution, whatever it is. You see, American Constitution, then French Constitution, German, everything is a product of revolution. But our constitution is an evolved constitution. Though there was revolution, constitution was not a revolutionary product. We started with Act of 1909, 1990, then 1935. 1935 Act, which was enacted by the Britishers, were almost transformed into our constitution. Isn't it? So we also fought with the imperialistic regime. We stood with them. We learned from them, and with suitable modifications, we adopted a constitution. While adopting the constitutions, preamble says justice, political, social, economic, equality, so many things. So a big chapter of fundamental rights have come. And these, then what happened? The rights, liberty, freedom, all these things have come to the forefront. But our entire criminal law is against that. So you have to reconcile, you have to balance the scale of justice to match the principles, the mandate, the philosophy of the constitution, and the working of your criminal justice system. Again, any law which was in force at the time of constitution, if it is not consistent with the fundamental right under part 3, what will happen to that? That will not be operative thereafter. Doctrine of eclipse will apply. And further, the new government cannot make any law which will infringe, take away, or limit your fundamental rights. These things are there. So, how to balance this, our criminal law system and the constitutional mandate? It led to the development of a new criminal jurisprudence in India. That will be very interesting to note. Okay, now coming to the Satyameva Jayate. But if you go to the Supreme Court, you will not find the Satyameva Jayate there. You will find another motto which is called the motto of the Supreme Court. Can anyone tell that? What is written in the Supreme Court? Instead of Satyameva Jayate? Anyone? Okay, I'll tell. Edo dharma sthado jaya. That is the motto of Supreme Court. Why? In all the codes you fight for justice on the basis of truth. When it comes to Supreme Court, that is the paramount seat of justice. There you cannot win only with truth. The truth must be backed with dharma. If it is devoid of dharma, see, there is no equivalent word in English for dharma. So that's why I'm doing as dharma. If your truth is also devoid of dharma, you will not. You will not win. Only truth, dharma wins. Who said this? Actually, Yado dharma stado jaya. Where there is dharma, there is victory. Who told to whom? Eh? Not Krishna. Gandhari to Kauravas. Every day, before the 18 days of war, every day, the children used to go to take blessings from her. She used to tell Yado dharma stado jaya. Even on the last day, when only one son was left out for the Duryodhan was remaining, he went and told, please bless me. If you bless, I will win. All your children have lost, only I am there. Open your eyes and see me. Then also she said the same thing. Yado dharma stado jaya. That is why that is the motto of the nation and motto of Supreme Court. So the constitutional exercise of developing criminal jurisprudence is to read or reinvent, inculcate, integrate the motto of the nation and the motto of Supreme Court into our legal system. That is Satyameva Jayate plus Yado Dharma Stado Jaya. See, I will tell you, while addressing the Singapore Arbitration Conference, our former Chief Justice N.V. Ramana said, I'll just read out from what he said. In Singapore Mediation Summit in 2021. He said, the Indian justice system is unique not only because of a written constitution but also because of the immense faith reposed by the people in the system. Why do you have the people, why the people of India have so much of faith in the legal system? You may know that there are corruption in judiciary, corrupt minds are there, corrupt practices are there. But as a society, we are not ready to accept it. Because we look upon to the judiciary as seats of justice. Why? Who gave the judiciary that much of sanctity? It is the constitution. Because constitution has given ample powers to the judiciary to transform the mandate and philosophy of the constitution into reality through decisions. That's why you call it as judicial review or whatever it is. Okay. So the constitution contains numerous provisions embedded in itself and a number of principles and doctrines and gives wide powers to the judiciary to life, bring to life the motto of the nation and of the Supreme Court. That is what Chief Justice N.V. Ramana said in Singapore. So, how this has affected our constitution? If you want to know how this has affected our criminal jurisprudence, you must understand the background of the IPC. Just like you just told, the first law commission headed by Lord Macaulay has drafted. And when the Britishers came to India, in majority of the Indian lands, Muslim law was being applied. And in our places, different legal systems were in place because there were not many princely states. Because there was nothing called India before Britishers came. It was only concepts, not a reality. So, till the passing of Charter Act 1833, Britishers never intervened with the domestic law. Different domestic law was administered in India. The only thing is that when it comes to their subject, they got that only English law will apply to them. that they have managed with the local rulers. Under the Charter Act of 1833, the Governor General Council was given legislative powers. It was further strengthened by Indian Councils Act 1861. And by virtue of these two legislations, the Governor General Council started making laws for India from 1834 to 1920. And whatever law made by the Governor Council was applicable only to British India. And the princely state, they have their own laws. Understand? So in 1834, the Law Commission submitted the draft of IPC. It was revised, resubmitted in 1856. It was about to be implemented. Then what happened? The first independence war, Sipahi mutiny came. Because of the rebellion, it was not implemented. Then it was again sent back for revision. It was revised by one person called Barnes Peacock, and it was submitted again to the council in the year 1860, and in 1862, with effect from 1862, January 1st, Indian Railroad came into existence. Then also it was applicable only to British India. When we become free independent, it was adopted as the principal criminal law of India and made applicable to the entire India except Jammu and Kashmir. And from October 31st, 2019, it is again applicable to all of India. But now we started transforming our criminal jurisprudence such a way, and our focus has shifted, not all of a sudden, gradually shifted from the penal angle of the law, from rendering justice, from penalty to rendering justice. So criminal law is not only to punish somebody, it is not only to maintain law and order, it is to provide justice to the whole concerned in the crime. That's why I told you crime as a social institution. What is the name suggested for the new penal law? Danda nahi, Nyaya Samhita. Shift from danda to Nyaya, punishment to justice, criminal justice administration, not penal justice, penal law administration, criminal justice also, Nyaya Samhita. So now you tell me, what are the key elements in administration of criminal justice? It starts with where? It starts with taking cognizance of the offence. First one. Second, registering FIR. Then comes investigation, arrest, then remand, or preventive detention authorities, then granting of bail, investigation, filing charge sheet, then trial before the court, finding by the court, sentencing, appeal revision, and lastly, you have something called special, what is that? SLP, special leave petition. This is not in the CRPC. It is nowhere. But still, there's a provision in the Constitution to prefer special leave petitions. Why? See, what happens? CRPC is all done CRPC. Okay, suppose a person is convicted, sentenced, punished in the lower court, what he will do? He will go to higher court for a what? Appeal. After that? After appeal, what is the remedy? Revision. But limited action, revision. So revision is also over. See, mostly your remedy in criminal case ends with the High Court. Appeal revision. Then you go to Supreme Court again, but not under CRPC. You are going under the Constitution, specially. Why? Because providing complete justice. Even I will tell you, even after Supreme Court, specially is also dismissed. Then again you can go ask curative petitions. There's no specific person, but still you go. You might have come across that Yaqub Mehman's case. Understand? The court sat up to early morning. Early morning. Why? Because he was to be hanged on the next day morning. Previous day evening comes to the court and says that I may be given a chance. The court took a special sitting. Why special sitting? Because no person should feel that अब मुझे एक चांस मिले तो कुछ होता था. He should not feel that I have been denied the chance of getting justice. See, last week, some law students filed a writ petition. What was the purpose of filing? You know why they filed. But the court sat on Sunday. Understand? The court sat on Sunday to dispose of the matter. Why? Because it is a new jurisprudence. Understand? Court would have very well said in the argument, you have been already dismissed, even the clemency petition is dismissed by the president, you go and get hanged. No. Because new jurisprudence, criminal jurisprudence speaks or mandates that justice must not be denied. You may recall the statement of Justice V.R. Krishna here, what he said. Justice must not only be done, but it must also seem to be done. Right? See, I tell you, as a teacher, I like all my students. But you should also feel, I like, isn't it? Likewise, say justice is done, but you should also feel that justice is done. So that was the one thing. Okay. Now, on all these grounds, there have been new jurisprudence have evolved because of the Constitution provision. Okay, tell me which all provisions in the Constitution will contribute to the development of criminal jurisprudence in India? Which all articles? 14, 19, 21, 22. Clear? Again? 32, 26, that is a procedural thing or enabling process. Now, we have seen crime as a social institution. So, who are the stakeholders in the crime? The victim, the offender, the state, the police, the prosecution, the defense, the families of the accused as well as the victim, then the society at large, the courts, then the prison administration, the sociologist, the psychologist, the lawyer community as a whole, and other facilitators of offense. All these people are stakeholders, and all these stakeholders have to be addressed differently, and all these stakeholders have to be given justice. That is what intended by the new law. You have to give justice to all these people. Suppose you are a criminal, you are a offender, you should also get justice. Of course, you may get punishment, but that punishment must be justified why you are punishing the person. Okay. Now, I think arrest, bail, seizure, and everything already done in other lectures, isn't it? So I do not go I will not go into all those things except whenever it is necessary. But we'll directly go to the constitutional impact. See, first one, let us take Article 14. It speaks about right to equality. It has two components. What are the components? One is equality before law and equal protection of laws. So, equality before law is used in the generic sense. It is explained by Professor A.B. Dicey. Professor A.B. Dicey says, every official, right from the Prime Minister down to a constable or a collector of tax, is under the same responsibility for every act done without legal justification. Every act done without legal justification, every person is under same responsibility. You be the Prime Minister or a constable, under the same responsibility. That is why there's a said, you be ever so high, the law is above you. The law which binds the sweeper binds the president, binds the, of course, the prime minister. So in this concept, only prime minister. Beyond that, law is not binding. So he has developed three principles which we collectively call as rule of law. First principle is that absolute supremacy or predominance of regular law as opposed to influence of arbitrary power. Second is equality before law or equal subjection to the ordinary law of the land administered by ordinary courts. Third one, laws of constitution is consequence of rights of individuals as defended and enforced by the court. This is very important. What is constitution? It is a sum total of individual rights. And those individual rights are to be defended, protected, enforced by the courts. The duty of the court is that. Suppose you take Indian Constitution. What is the operative part of Indian Constitution? Only part 3. Other things is social science, social studies. Isn't it? So Constitution develops through part 3, the fundamental rights. We have big, very large, lengthy Constitution. But the operative part is only part 3. Under part 3, which is the most important article? But which is the most important right? Yes, exactly. Your name? Anamika, very good. Though your name is Anamika, you have made a name here. Okay. So, Article 21, right to life and personal liberty. So, these rights have to be protected by the courts. So, I am telling you, the criminal laws were enacted by British governments to restrict your rights, to oppress your rights. And the Constitution says your rights have to be protected. Who gave you the constitutional rights? Who gave you the fundamental rights? Tell me, yes. Okay, is it constitutional creation? No. I'll tell you why it is not. Okay. So, coming back to Article 19, it speaks about freedom. And the freedom, the beauty of Article 19 is that freedom, how many freedoms are given? Freedom of speech and expression, most important. Assemble peacefully, the freedom of association, move freely, freedom of movement, freedom of residence, and participate in profession, and 6 freedoms you have now. 1 freedom has been removed. And all these freedoms are subject to reasonable restriction. So this is clause 2 again says nothing in subclause A of clause 1 above shall affect the operation of any existing law or prevent the state from making any law insofar as such law imposes reasonable restrictions on the exercise of right. So any penal law, every penal law is restricting your rights. So if it is restricting your right, whether that restriction is reasonable within the ambit of Article 19 or not, that is to be tested. If it is not reasonable, it goes beyond the permissible limit of reasonableness, then that law is invalid. So the first case in this angle came was A.K. Gopalan versus State of Madras. How many of you have heard about the case? Because this is the point from where the new criminal jurisprudence has been developed in India. A.K. Gopalan was a member of parliament and also leader of opposition in the first parliament. He was a communist party leader. He was detained under preventive detention. What is preventive detention? Have you committed any crime? No. The state feels, government feels that he may do some crime, or if he is outside, that will create certain problems. So put this person inside. So there is one act for that. That act name was Preventive Detention Act 1950. Understand? Very difficult. Very difficult. When India became a republic, in which year? 1950. Preventive Detention Act is enacted 1950. Not by Britishers, by the independent government. The government of the people who fought against the preventive detention of Britishers, after coming to power, they drafted a law which will enable the government to take person under preventive detention. That is why Lord Acton said, power corrupts and absolute power corrupt absolutely. Because so far as Britishers were ruling, I was very much agitated. You curtail my freedom, you arrest me, you put me under preventive detention. It's all against liberty, against freedom. But when I came to power, I also drafted the same law. Because when I come to power, I do not want opposition voice. I do not want to dissent. So he was taken preventive detention. He came to the Supreme Court for court and filed it to Supreme Court. And major arguments was one was that the preventive detention violates the act violates the principles of natural justice, and therefore it violates Article 21. What is Article 21 says? No person shall be deprived of his life or personal liberty except according to procedure established by law. So this is why, that's why I told you this is the most important right. Because only what it says you can deprive, but only by a procedure established by law. No other ground is there for restricting that. Second is, there's a freedom of movement under Article 19(1)(d). That is also violated by preventive detention. And what are the grounds for restricting freedom of movement? Under clause 5 of Article 19, it says, interest of general public, protection of interest of any scheduled tribe, and it does not speak about preventive detention. Therefore, this is not a reasonable restriction. Another thing, under Article 21, the British concept of the US concept of due process of law is contained. That is not followed here. These arguments were raised before the Supreme Court, but unfortunately, Supreme Court rejected the arguments. Supreme Court said that, in this case, Supreme Court said that, first of all, Article 21 does not speak about due process of law. What it speaks about a procedure established by law. So what is required? There must be a law, and that law must prescribe some procedure. If that is followed, it is fine. No, natural justice is not law. Law means enacted law. Principles of natural justice is not law. Another thing what they said is, Constitution gave the final word to decide what is law or what should be law to the legislature, not to the judiciary. And judiciary shall not read natural justice such things into that. And more dangerously, it was said that Article 21 and 19 are not supportive or complementary, they are mutually exclusive, totally different, because Article 19 speaks about certain specific rights, whereas Article 21 talk about life and liberty. These two things are totally different. You cannot club together and see. And a law cannot be held unconstitutional just because there is no it is not following natural justice, or it lacks what is it, due process. Therefore, the case was dismissed. So that is the starting point. But in every major decisions, you must understand, it is the beauty of Indian constitutional development. In major decision, there will be a minority dissenting judgment. Most of the time will prove that the minority view was correct. In this case also, Mr. Justice Faisal Ali, he gave a minority dissenting judgment. He said, if the judiciary will not give importance to reasonableness, there can be situations of dictatorship. Principles of natural justice not being followed and so on, it will be dangerous. So this view expressed by, in which year, Ekagavan case? 1950 itself. First, that's why it was the first case. So in this, the view expressed by Justice Faisal Ali in 1950, though it was dissenting judgment at that time, that was a futuristic opinion. From here, we will see the landscape of development of criminal jurisprudence and impact of constitution. Immediately after that, 1952, another case came, State of West Bengal versus Anwar Ali Sarkar. आप सुने हैं केस के बारे में? It's a very good case. 1952 Supreme Court 75. AR 1952 Supreme Court 75. In this case, Anwar Ali Sarkar and 49 other people, totally 50 people, were charged for an offence of murder. See, the charge is that they formed a mob. They entered the factory in Dum Dum, Calcutta. The factory was Jesop Limited. They assaulted the officers. There was a problem, and they battered them to death. And the body was thrown to the burning furnace in the factory. So it was a major offence. Then the Bengal state government passed a law, Special Courts Act, under which special courts are established to give speedy trial. And you have seen speedy trial is also part of Article 21. A.R. Anil case you have seen. Speedy trial is one of the fundamental rights. So to do this speedy trial, a special court was established. Is there any wrong in that? No, nothing wrong, because speedy trial in certain cases is very good. The matter came to Supreme Court. Supreme Court said it is good, but which case shall be given for speedy trial? There is no criteria. Absolute discretion is given to the state government. It is unreasonable. It is violating Article 14. Understand? See, what is the test of reasonableness under Article 4 at that time? There must be a rational classification, basis for classification, intelligible differentia, that is what word used. There must be a rational ground for classification, and there must be a reasonable nexus connection between the classification and objects sought to be achieved. Here, objects sought to be achieved in speedy trial. So, government can do at whims and fancies. In any case, they can select as an for speedy trial. So, it is not constitutional. It is unconstitutional. So, that was a. But though they expressed this view, the decision in A.K. Gopalan case was not overruled. But there is a slight deviation. Then came Bennett Coleman Company versus Union of India case. Who is Bennett Coleman Company? How many of you have read or reading Times of India? paper. How many of you seen Times of India paper? Okay. Who is the owner of Times of India? Bennett Coleman Company. So last paper नीचे देखने को बोलते England published by Bennett Coleman Company. They are the owners of Times of India. So they challenged an order. It was with respect to newsprint, nothing to do with speech, speed of speech and expression. So there, in this case, the Supreme Court has taken Article 19(2). The restrictions were considered in the light of Article 19(2) and said that these restrictions are directly affecting the freedom of speech and expression, because if the paper does not have sufficient pages to print, how they will express the views? The freedom of press is also part of freedom of speech. In India, it was not like that. So in these cases, freedom of press is also part of freedom of speech and expression. Therefore, it was further struck down. Further deviation from A.K. Gopalan case. Then came R.C. Cooper case, 1970. R.C. Cooper case is with respect to what? Bank nationalization. Bank nationalization. So in this case, for the first time, Supreme Court said that it took up a totally different stand from A.K. Gopalan and said that to understand what shall be the test, it is not the object test. Test must be effect test. Not your object, what is the effect? That is to be considered. So, banks were nationalized. So, it violated the right to property of the shareholders of the bank. That time, right to property was also a fundamental right. Then the court said, we have the duty to protect. How much more time? Okay. Fine. So we have the duty to protect the fundamental right from any kind of infringement by the state. Any kind of infringement. So here what happened? The entire decision A.K. Gopalan case has been overruled by the court in R.C. Cooper. Now, till now, Article 14, 19, 21, they were treated separately. But again came the most celebrated case after the Keshwan case in Indian Constitution. That's Manila Gandhi case. In Manila Gandhi case, you know what happened in case? Her passport was impounded under the provision section 10(3)(c) of the Indian Passport Act 1967. So there are 4 grounds by which a passport can be impounded. One is interest of the general public, security and integrity of the country. Next is important foreign relation with the foreign state. There are 4 grounds like this. And the problem was that the passport officer had the power to impound the passport even without giving a notice or any reason. So when the matter came to Supreme Court said that your right to impound passport is okay. It is not unconstitutional. But the power to impound anybody's passport at any time without even giving a notice and without telling a reason, it is unconstitutional, because it is very arbitrary, right? So here, in this case, that time Chief Justice H.M. Bell, he said, he relied upon. That's why I asked you whether fundamental rights are given by Constitution or not. He relied upon the decision of Supreme Court in I.C. Golagnath versus State of Punjab as early as in 1967 and said that the fundamental rights are natural rights embodied in the Constitution itself and are above all. So fundamental rights are not the creation of Constitution. It is not the Varadan of Constitution. It is not the gift of constitution. It is your natural right. Constitution is only embodied into itself. It is above all. It cannot touch. So it is arbitrary. Then he again said that fundamental rights are not different and separate. All the fundamental rights mentioned in Part 3 of the Constitution form part of the same integral scheme. Their water can be mixed to constitute a grand flow of unimpeded and impartial justice. So Article 14, 19, 21, you cannot say they are three different rights. It's a combination. It will join together and flow of justice will be created. And the court said there exists a golden triangle between 14, 19 and 21. And Justice Bhagavati was also in the bench. Bhagavati said, court shall try to expand the scope of fundamental rights. Court shall always remember that fundamental rights are higher law and they should never try to infringe them. He again took the reference of human body. Suppose your leg is injured. Will you not take your hand there and see what happens? So can you say that it is like hand should not come there? Or your hand is injured, will your eye look into that? Can you say I should not look, it is only a matter of hand? It is like that the fundamental rights. Every fundamental right is a combination of the main body principle. So no separation. Then they are it is not mutually exclusive, but they are mutually supportive. And at the same time, another case came, though not directly with criminal law, but it has tremendous importance in criminal law. Just like Mena Gandhi case, that is called E.P. Royappa versus State of Madras. State of Tamil Nadu. It was related to the transfer of an IAS officer, frequent transfers, but the court struck down on the arbitrariness, arbitrary actions. The court said that equality is a dynamic concept with many facets and dimensions. It cannot be cribbed, cabined, or confined within the traditional doctrinal limits. He said, again, Justice Bhagavati said that equality is the antithesis of arbitrariness. In fact, equality and arbitrariness are sworn enemies. One belongs to the rule of law. Which belongs to the rule of law? One belongs to the rule of law, while other to the whim and caprice of an absolute monarch. One belongs to rule of law, other to the monarchy. Which one belongs to rule of law? Equality or arbitrariness? Naturally equality, isn't it? And arbitrariness belongs to the monarchy. So you have rule of law, you cannot have arbitrariness. So whether you are a police officer, whether you are a court, even a judge, you cannot take anything arbitrarily. You have to follow the principles of law. So following this, not many cases have come. Even you might have heard of the famous case Husainara Khatun versus State of Bihar, Home Secretary State of Bihar. In that case, lot many people were in jail. They were undergoing imprisonment for 12 years, 8 years, 10 years. Under 12 prisoners awaiting their trial. But the funny thing is that if the offense for which they are charged, if they come and say, I plead guilty, they may be punished for 3 years or 4 years. To get a punishment of 3 years or 4 years or 5 years, you are waiting in jail for 8 years to 12 years. Saying that courts that we have granted bail, but nobody to take them. Sureties are not there. See, those who practice, they will come to know all these things. कोर्ट ने बोल दिया हम लोग बेल तो दे दिया, श्योरिटी किधर है? In this case, the Supreme Court said that release them on personal bond, PR bonds, and try to set off the period which they have undergone. Then again, the speedy trial, of course, manner that AR have told you. Another case, see, even delay in trial, how the balance is coming. Another case is that in AR Antule case, the court said that the period accused were in jail and the time taken for investigation, trial, everything should be considered when you think of speedy trial. The investigation takes 6 years. You cannot say speedy trial is there. The court cannot say that Mera Samne case aaya nahi. So all this should be taken together. So then came a case called Ranjan Dwivedi versus CBI, where trial went for 37 years. See, it was it is known as seen a former Railway Minister of India, Sri L. N. Mishra, was assassinated in a bomb attack, and that trial went for 37 years. So, writ petition was filed before Supreme Court to quash the trial, but that writ petition was dismissed, saying the delay is there. We condemn the delay, but just because trial is being delayed, your criminal responsibility will not be taken up. So, understand? Speed trial is part of your fundamental right, but criminal responsibility will not be absolved because of delay. So that is how they have managed the balance of justice. Okay. And another case, this also you are aware, Nambi Narayan versus C.B. Matthew, where a scientist of ISR was arrested under the charge of espionage, spying. But for 15 years, government was not, or the investigating agency was not able to give a satisfactory reason why he was arrested, what was the charge against him. So his charge was scrapped, quashed, and also compensation of 50 lakhs rupees was granted to him. This I was telling about commercial jurisprudence in criminal law. Okay, so but the thing is that he was arrested at the time when he was plus 60 plus. God gave him long life so that he could receive compensation after 15 years, after 75 years of age. These are also other things. Okay. Now, custodial death and torture. In the prisons, prison is also another stakeholder of the criminal justice. So, see, how many of you have gone to police station? Okay. Police station, yeah, not for legal aid, either as a complainant or as an accused. Are you free to? Okay, are you free to walk into the police station, or do you have a fear? Psychological fear is there. Yes. Why? See, the thing is that what is police station? It is a public office for your service. You should be as free as you go to the railway platform and go to the inquiry counter and madam ये गाड़ी का time कब आएगा वो कौन सा भाषा में पूछते हैं ना, you don't feel any fear. So the moment you feel that much ease in entering the police station, we can say that access to justice is there. Otherwise, access to justice is not there. Because police station is the place where you have to seek first protection. उधर ही आपको डर के जाना बोले तो what is access to justice? Isn't it? So in so many cases, court has said that D.K. Basu versus State of West Bengal, the post arrest behavior, so big guidelines have been given, isn't it? You have to see that. Because of lack of time, I am not taking all those things. But another thing you have to understand is handcuffing and keeping handcuffing as a custodial person. Prem Chandra Shukla was Delhi administration. Court said once a person is arrested and remanded to custody, no handcuffing, and even handcuffing is not required unnecessarily. And another thing, Sunil Batra versus Delhi administration. What all, see, the torture the people are undergoing in jails, custodial torture, violence, it was brought to the notice of Supreme Court by Sunil Batra, and court has taken serious objection to that, and a lot of guidelines are issued in this case. And he said that by prisoner being an offender, that does not mean that he has no fundamental rights. He has every fundamental right, every constitutional right. He said the right of under Article 21. It can break the barricades, it can break the gallows, and it go into the darkest corner of the jail, and it will help the person. So just because he is an offender, you cannot say that he has no right. He has every right, every right. And a lot of he cannot be treated with contempt, brutality, or disrespect or inhumanity. And lot of directions were given to treat a person with dignity, to allow him to follow religion, culture, language, to communicate with family and friends outside the jail. Then no subject, no type of discrimination. And again said death penalty, even though death penalty is to be awarded, it must be executed without any pain or with the minimum possible pain. See, the government, as per the court orders, we have studied what is the best method of executing death sentence. Almost 3-4 years, death sentence stopped, and found that death by hanging is the best method. Recently, you might have seen in USA by nitrogen gas. Just 1 week before only, gas chambers, shooting, giving poison, everything is more painful than hanging. That is what the finding. Then adequate sanitation, also all those things were given. And two things I want to tell you about without changing the text of the act, how constitution is impacted. Bachchan Singh versus State of Punjab, case you know. That is with respect to the constitutional validity of death penalty. See, IPC section 302 says what? Whoever commits murder shall be punished with, what is the punishment for murder? Death penalty. Punished with death or life imprisonment. So, principal punishment is